So a preliminary hearing, you'll get a form at your bond hearing asking you whether you want to request a preliminary hearing. That's nothing more than a probable cause hearing. It's going to go before a summary court judge, and the affiant on the arrest warrant or the chief investigating officer, if the law is followed, will be the one testifying at that hearing. Now, that gives the defense attorney an opportunity to cross-examine them under oath. It's one that I rarely give up. Many attorneys will waive the preliminary hearings, but I believe they're so critical. There's very few opportunities in our current system in South Carolina to be able to cross-examine these officers under oath. And so there can be some pivotal moments or information learned at these preliminary hearings, or possibly the case being dismissed at the preliminary hearing, depending on the cross-examination and the evidence that's presented. And it's certainly a great investigative tool to be prepared for trial. Now, if your case was dismissed at the preliminary hearing, it doesn't mean that the case is gone forever. The prosecutor still has discretion whether to do a direct presentment of an indictment. And so it can be sometimes one of those things where you have the victory at the preliminary hearing. It doesn't mean that the case stops there. However, the prosecutor with their discretion doesn't have to send the case for a direct indictment. But that's a big pivotal point, that if a case gets dismissed, it puts the prosecutor on notice that the case isn't as strong as they believed it once was.